Look, everyone has to use contracts in business, especially small business. You're going to be signing contracts with vendors, signing contracts with other people, signing contracts with your customers and clients. We want to make sure that the contract is serving your purpose on either side of the table. The way you do that is you always ask these 8 questions. Number 1, what do you want out of this contract? Before you sign a contract or agreement, you need to ask yourself, why am I entering into this deal? What will I gain by signing this agreement? Does this contract take me closer to achieving my goals or further away? I recommend you actually write out the answer to that question. Number 2, does this contract identify important dates, deadlines, milestones, when a report's due, maybe a payment's due, etc. Maybe your performance is date specific, and if you perform a day late, you breach the contract. Maybe the date in the contract is going to make it impossible for you to perform because of a pre-existing obligation. That's not the same as a hurricane hitting and making it impossible for you to perform. Your schedule isn't a contractual impossibility. It just created a huge problem for you and put you in a breach. You can avoid this problem by checking all the dates before you sign a contract. Without a system for doing that, you blow through those things. So check the dates carefully. Number 3, who are the necessary parties to this contract? At the top of almost every contract or agreement, you'll find a section that says this contract is between parties A and party B. You glance at it and you make sure your name is on there. Maybe you check to see if you recognize the other party's name. Well, what if the other party's name isn't quite right? Does it matter? It really does. If your contract does not contain the correct parties, it could create liability for a person or entity unintentionally. For example, if you run your business as a corporation and the contract has your personal name, you just created personal liability and all the benefits of having the corporation in place are gone. Number 4, does the contract clearly describe the amounts of money or other consideration for contracts? Every contract should clearly set out and describe the amounts of money or other considerations that are being transferred between the parties, but that is not always the case. Ambiguity in this part of a large contract can be fatal to a small business. Look for those dollar signs, highlight each and every place where money is referenced. It's probably going to be around some of those dates. If you're paying money in this contract, you don't want to pay a penny more than you're supposed to. If we're receiving it, we want to make sure we get the right amount. So we focus on the money. Number 5, what are the remedies that this contract contains for any breaches that occur? The next thing you want to look at are what are the remedies for default? If you're going to go through the trouble of having a written agreement, then you need to know what happens if someone breaks it or defaults. Well, you have options that you can put in the contract. We need to look through the contract and see what the options are. What happens if I default? What's going to happen if they breach the agreement? If the contract only addresses your default and not anything if they default, that's not fair. We need to go back and ask for that to be balanced out. There needs to be equal punishment. Number 6, are the rights and obligations and duties of every party clearly listed? Are they understandably set out? Now, we're going to go through and highlight all the things that we have to do that may not be money related. Is it clear and understandable to where someone with a 7th grade education can understand what you have to do? If it's hard to understand, it needs to be rewritten. When we put this in front of a jury of our peers, believe me, you want to be at a 7th grade reading level. You want it to be very, very understandable. There should be no doubt of what you were supposed to do and what you weren't supposed to do. Number 7, will your state's laws apply to this contract? This is an often overlooked part of most contracts. Did you know that you could choose which state's laws apply to your deal? You can even choose where litigation, if necessary, would happen. Generally speaking, you want the contract to be governed by your state's laws, and in litigation to occur in your backyard and not theirs. Okay, the 8th and final question is how will disputes related to this contract be resolved? When you put the gloves on and go into the ring for litigation, every case has an opportunity, at least one, to be resolved. There's a point where it can be settled. In the contract, we want to know how are we going to do that? Are we going to use mediation? Is there going to be mandatory mediation clauses that before we ever step foot in the courtroom, we have to take a dispute to a mediator? Are you going to do arbitration? There are pros and cons to both. We want something in that contract that can keep us out of court, if we want to be out of court. If you have to go to court, then that all becomes public record. Pre-litigation mediation can be private and not available for public scrutiny. And if you go to arbitration, it's also not public record. That's private. Sometimes there are things that happen in business that we don't want to be public record. We don't want everyone to know. There can be great value in being able to claim that you or your company have never been sued. Look at that part of the contract. Is there an alternative dispute resolution clause, mediation, or arbitration? I'm Scott Reeb, America's Legal Coach with Reeb Law.